In this module, I want to talk about individual rights under the Constitution. I specifically want to cover 4 topics with regard to individual rights. I want to talk about the requirement for state action. This is basic and applies to all protection of rights or equality under the Constitution. The idea that the Constitution and its protection of rights and equality applies only to the government, not private conduct. Then I want to talk about the provisions of the Constitution that limit retroactive legislation, that limit the ability of the legislature to punish or regulate conduct that's already occurred. Another topic that I want to cover, the third, will concern procedural due process, the procedures that government must follow when it takes away a person's life, liberty, or property. Finally, I want to cover the takings clause, that when the government takes private property for public use, it must pay just compensation. All of the topics that I'm covering here deal with regularizing government power in the way that it treats individuals. That's why we prohibit retroactive legislation. That's why we require procedural due process. To require just compensation when the government takes property. It's all about regularizing how the government treats people within the country. Now, I've labeled this module individual rights, though there are obviously individual rights that I'm not covering in this module. I'm going to have a separate module on substantive due process and on equal protection. And then there'll also be a separate module on the First Amendment and freedom of speech and religion. And of course, though they are individual rights, I'm not going to be covering criminal procedure, the 4th, 5th, 6th Amendment rights, because there's a separate lecture to cover those topics. So I'm going to look at 4 topics with regard to individual rights. I'm going to talk about state action. I'm going to talk about limits on retroactive legislation. I'm going to talk about procedural due process. And finally, I'll do the takings clause. Let me start then with A, the requirement for state action, or better phrased, the requirement for government action. Point 1 under A. The Constitution applies only to the government. Private conduct does not have to comply with the Constitution. The Constitution applies only to the government. Private conduct does not have to comply with the Constitution. This is a basic principle of constitutional law. The Constitution's protection of rights, its guarantee of equal protection, limits only what the government can do, doesn't apply to private conduct. To illustrate, a couple of examples. Before I took my current job, I was a professor at Duke Law School. Imagine while I was there, I gave a speech criticizing the president of Duke University. Or I guess I should say, if I again gave a speech criticizing the president of Duke University, and imagine that he ordered me fired. I could not sue him or the university for violating my First Amendment rights. Since Duke is a private university, the Constitution and the First Amendment don't apply. Now, though, I'm professor at the University of California, Irvine School of Law. It's a state university. Imagine I would give a speech criticizing the president of the university, and she was to order me fired. I could sue. I would sue. Since the state university, the First Amendment and the Constitution apply. My other illustration here comes from a true story of a conversation that I had with my oldest 2 children 23 years ago when they were 9 and 6 and we were in a grocery store together. At the time, Diet Coke was giving away free baseball cards, and 3 cards were pictured on the outside of the package. As we went up and down the aisles of the grocery store, my 2 sons were fighting, as they often did at that age, but who was going to get the extra baseball card? Finally, I said, be quiet. I don't want to hear anything else about baseball cards to leave the grocery store. My then 9-year-old turned to me and said, you can't tell me to be quiet. I've got freedom of speech. Well, I was ready for him. I said, freedom of speech means that the government can't tell you to be quiet. I'm not the government, so I can. To which he, without missing a beat, turned to me and said, "Well, you're like the government to me, so you shouldn't be able to tell me to be quiet." This was when I first knew that someday he was going to go to law school and be a lawyer. In fact, now he's an assistant United States attorney in Los Angeles. This principle is sometimes referred to, as I have labeled it, the state action doctrine. But state action is a misnomer. The Constitution applies to government at all levels, federal, state, and local. It's just that private conduct does not have to comply with the Constitution. Point 2, Congress by statute may apply constitutional norms to private conduct. Congress by statute may apply constitutional norms to private conduct. I just said that the Constitution of its own force applies only to the government. But as you know, Congress by statute can regulate private behavior. Such laws can require that private actors meet the same standards that the Constitution imposes on the government. Easy example. Think of race discrimination. If a government entity discriminates based on race, it can be challenged for denying equal protection of the Constitution. But if a private entity discriminates based on race, equal protection of the Constitution don't apply. But Congress can, and Congress has, adopted statutes that prohibit private race discrimination. In that way, Congress by statute has applied constitutional norms to private conduct. To be more specific, sub A, pursuant to the 13th Amendment, Congress may prohibit private race discrimination. Pursuant to the 13th Amendment, Congress may prohibit private race discrimination. The 13th Amendment prohibits slavery and involuntary servitude. It is one provision of the Constitution that applies directly to private behavior. It says that people cannot be or own slaves. Additionally, Section 2 of the 13th Amendment authorizes Congress to adopt laws to enforce the 13th Amendment. The Supreme Court has said that Congress has broad power under Section 2 of the 13th Amendment to prohibit private race discrimination. Congress, according to the Supreme Court, can legislate to, I'm quoting, eradicate the badges and incidents of slavery. Simply put, pursuant to Section 2 of the 13th Amendment, Congress can adopt statutes that prohibit private race discrimination. Sub B, pursuant to the Commerce Clause, Congress can apply constitutional norms to private conduct. Pursuant to the Commerce Clause, Congress can apply constitutional norms to private conduct. One of the most important statutes adopted in my lifetime was the Civil Rights Act of 1964. Among other things, Title II of that act prohibits hotels and restaurants from discriminating on the basis of race. Congress adopted this law pursuant to its Commerce Clause authority. You might remember here a famous case that challenged Congress' authority. It was a case that involved Ollie's Barbecue, Katzenbach versus McClung. Ollie's Barbecue is a small restaurant in Birmingham, Alabama. It refused to admit or serve African-American customers. It was sued for violating Title II of the 1964 Civil Rights Act. It defended by saying that it wasn't part of interstate commerce. It was just a small restaurant inside a state serving homemade barbecue. But, as you know, the Supreme Court ruled against Ollie's Barbecue. The Supreme Court noted that much of Ollie's Barbecue supplies, including its meat, came across state lines. Even more importantly, the Supreme Court said, when it looked at all of the restaurants across the country that discriminated based on race, cumulatively, there was a substantial economic effect. Thus, Congress could use its commerce power to apply the constitutional norm of equality to private conduct. However, sub C under point 2, pursuant to Section 5 of the 14th Amendment, Congress cannot regulate private behavior. Pursuant to Section 5 of the 14th Amendment, Congress cannot regulate private behavior. Under Section 5 of the 14th Amendment, Congress can regulate only state and local governments. Under Section 5 of the 14th Amendment, Congress can regulate only state and local governments. This was initially the holding of a Supreme Court case in 1883. It was reaffirmed in 2000 that Congress cannot, when legislating under Section 5 of the 14th Amendment, regulate private behavior. It's a power only to regulate state and local governments. Finally, point 3 under subunit A about state action, exceptions. In point 3, I want to talk about exceptions to the state action doctrine. There are a couple of narrow exceptions where private conduct has to comply with the Constitution. And they are narrow exceptions. A here is the public functions exception. The public functions exception provides that if a private entity is performing a task that's been traditionally exclusively done by the government, the Constitution applies. If a private entity is performing a task that's been traditionally exclusively done by the government, the Constitution applies. You might remember some of the famous cases here. Perhaps the most famous was Marsh versus Alabama in the 1940s. Marsh versus Alabama involved a company town. A company literally owned all the land in the town and ran the town. Some Jehovah's Witnesses came there and wanted to distribute their literature. The company said, "This is private property, get out." But the Supreme Court ruled in favor of the Jehovah's Witnesses. The Supreme Court said, running a town is a task that's been traditionally exclusively done by the government. When a private entity does it, it has to comply with the Constitution. Another example here are the so-called white primary cases. At the turn of the 20th century, Texas refused to allow African Americans to vote. When Texas was ordered to enfranchise blacks, it said it would no longer hold political primary elections. It would let the political parties run their own primary elections. And the political parties then refused to allow blacks to participate. But the Supreme Court said, holding an election for government office, even a primary election, is a task that's been traditionally exclusively done by the government. When a private entity does it, it has to comply with the Constitution. But I do want to stress what I said. This is a narrow exception. To remember how narrow, you should keep in mind the case of Jackson versus Metropolitan Edison. Jackson versus Metropolitan Edison involved a private utility company that went to terminate a customer service. The law is clearly established that before a government-owned utility can terminate a customer service, there has to be due process. There has to be notice into hearing. The question was, did the private utility have to provide due process before it was going to cut off the customer's service? The customer, of course, said, running a utility is a public function. The customer said, the utility has a state-granted monopoly. The Supreme Court ruled in favor of the utility and against the customer. The Supreme Court explained, running a utility is not a task that's been traditionally, exclusively done by the government. There have long been private utility companies. Thus, no state action in the Constitution doesn't apply. The other exception, sub B, is called the entanglement exception. The entanglement exception provides that if the government affirmatively authorizes, encourages, or facilitates unconstitutional conduct, the Constitution applies. If the government affirmatively authorizes, encourages, or facilitates unconstitutional conduct, the Constitution applies. Either the government must stop what it's doing, or the private conduct must comply with the Constitution. As I said, either the government must stop what it's doing, or the private conduct must comply with the Constitution. The problem with the entanglement exception is that the cases don't neatly fit together. There are inconsistencies among the cases that the Supreme Court's never reconciled. Therefore, the only way to understand the entanglement exception is to be familiar with the leading cases about it. I want to describe them to you. The first that I want to talk about establishes the principle that courts cannot enforce racially restrictive covenants. Courts cannot enforce racially restrictive covenants. This was the holding of Shelley versus Kramer. A racially restrictive covenant is a contract among members of a neighborhood that they wouldn't sell their property to blacks or to Jews. The court said, for a court to enforce a racially restrictive covenant is for the government, through one of its branches, the judiciary, to facilitate discrimination. Second example here. There is state action when the government leases premises to a restaurant that racially discriminates. There is state action when the government leases premises to a restaurant that racially discriminates. Wilmington, Delaware ran a parking authority. The parking authority leased space to the Eagle Restaurant. The Eagle Restaurant refused to admit or serve African American customers. The Supreme Court said, for the government to lease space to a restaurant that racially discriminates is for the government impliedly to authorize discrimination, for the government to facilitate discrimination. The court said if the restaurant wants to stay on government property, it has to stop discriminating. If it continues to discriminate, the government must exclude it. Third example. There is state action when the government gives free books to private schools that racially discriminate. There is state action when the government gives free books to private schools that racially discriminate. What's involved here is the state of Mississippi adopted a program of giving free textbooks to all private and all public schools in the state. The private schools included those that were racially segregated. In Norwood versus Harrison, the Supreme Court declared this unconstitutional. The Supreme Court said, when the government was giving the free books to the private schools that were racially discriminating, the government was encouraging, facilitating discrimination. The court said, if the schools want to continue to get the books, they've got to stop discriminating. If they continue to discriminate, no longer can the government give them this aid. Fourth example. There is not state action when a private school, it's over 99% funded by the government, fires a teacher for her speech. There's not state action when a private school, that's over 99% funded by the government, fires a teacher because of her speech. This was the holding of Rendell Baker versus Cone, 1982. There was a private school in Massachusetts. It provided special education. It was almost 100% funded by the government. A teacher criticized the principal and she got fired. Some other teachers spoke up on her behalf. They got fired too. They sued and said the almost 100% government subsidy should be seen as enough government entanglement for the Constitution to apply. But the Supreme Court ruled in favor of the school and against the teachers. The court stressed that the state of Massachusetts hadn't in any way encouraged firing teachers because of their speech. The court articulated a principle that's followed to this day. Government subsidy is insufficient for a finding of state action. Government subsidy is insufficient for a finding of state action. The fact that a private entity, like a private college or university, gets government money is not enough to make the Constitution apply. Fifth example. There is not state action when the NCAA orders the suspension of a basketball coach at a state university. There's not state action when the NCAA orders the suspension of a basketball coach at a state university. Jerry Tarkanian used to be the basketball coach at the University of Nevada at Las Vegas. The National Collegiate Athletic Association ordered him suspended for recruiting violations. He sued and said that he should be given due process. He said, after all, he worked at a state university. He said the NCAA is largely made up of public college universities. but the Supreme Court ruled against Tarkanian. The Supreme Court said the NCAA is a private entity, so it doesn't have to comply with the Constitution. As you look at these 5 examples, you can see there are inconsistencies among them. But you might say you see a pattern. You might say if it's a case involving race discrimination, then the court appears willing to apply the entanglement exception. After all, Shelley and Burton and Norwood were all race cases, my first 3 examples. The entanglement exception was found to be met. On the other hand, if it's a claim other than race discrimination, the court appears unwilling to apply the entanglement exception. Rendell Baker was about free speech. Tarkanian was about due process. And the court said the entanglement exception didn't apply. This pattern often works, but not always. And that's why I'm going to tell you about 2 more examples. 6th example, there is state action when a private entity regulates interscholastic sports in a state. There is state action when a private entity regulates interscholastic sports in a state. This was Brentwood Academy versus Tennessee School Authority. What's involved here is Tennessee has delegated the regulation of high school sports to a private entity. That private entity went to impose sanctions, punishments on a school, the Brentwood Academy, for recruiting violations. The school sued and said it should be given due process before sanctions were applied to it. The Tennessee Athletic Association said, no, we're a private entity, just like the NCAA. The Constitution doesn't apply to us. The Supreme Court ruled in favor of the school and against the Tennessee Athletic Association. The Supreme Court pointed to, quote, the entwinement between the government and the private entity. The court noted that the state of Tennessee had delegated regulating high school sports to this private entity, the Tennessee Athletic Association. The court said 85% of the members were public schools. Over 85% of the money for the Tennessee Athletic Association came from public schools. It usually met on public school premises. The court said there was so much entwinement between the government and the private action that the Constitution should apply. Yet I still wonder, what's the difference between the NCAA, an entity that regulates sports that doesn't have to comply with the Constitution, and the Tennessee Athletic Association, an entity that regulates sports that has to comply with the Constitution? The only distinction the court gave was to say that the NCAA operates all over the country, whereas the Tennessee Athletic Association operates in only one state. But I'm not sure why that should matter in terms of the question, was there government action? 7th and final example. There is not state action when a private club with a liquor license in the state racially discriminates. There's not state action when a private club with a liquor license in the state racially discriminates. Case involved a Moose Lodge in the state of Pennsylvania, and it had a liquor license in the state. It refused to admit or serve African American customers. The challengers argued that the grant of the liquor license was enough entanglement for the Constitution to apply. But the Supreme Court ruled in favor of the Moose Lodge and against the challengers. The court rejected the argument that there was enough entanglement for state action. The bottom line was that the Moose Lodge could keep its liquor license and also continue its discriminatory policy. So that completes my first topic for this module. A, is there state action? B, my second topic, limits on retroactive legislation. Retroactive legislation is where a legislature, Congress, a state legislature, a city council, adopts a law that prohibits or creates liability for conduct that's already been done. It just seems unfair to us to punish somebody or hold somebody liable if their conduct was lawful when it was done. So there are a number of constitutional provisions that limit retroactive legislation. I want to go through those provisions with regard to retroactive legislation for you now. Point 1 is the ex post facto clause. The ex post facto clause is the most important limit on retroactive legislation in the Constitution. Specifically, what the ex post facto clause provides is that a state or the government cannot punish conduct that was lawful when it was done or increase the punishment for a crime after it was committed. The government cannot criminally punish conduct that was lawful when it was done or increase the punishment for a crime after it was committed. Article 1, Section 9 of the Constitution says that Congress cannot adopt ex post facto laws. Article 1, Section 10 says that no state can adopt an ex post facto law. The example I use in my class students, I say, imagine that tomorrow the California legislature adopts a statute prohibiting the use of puns in lectures. And imagine that I'm prosecutor of that statute for all of the puns I've told this semester up until now. I said, my sense of humor might be painful to you, but it's legal. And to punish me under a law adopted tomorrow for what I did today or yesterday is the very essence of an ex post facto law. Just unfair to punish a person for something that was lawful when it was done. It's unfair to increase the punishments for a crime after the crime was committed. That then is what it's an ex post facto law. It's where the government criminally punishes conduct that was lawful when it was done or increases the punishment for a crime after it was committed. This, as I said, is the most important limit on retroactive legislation in the Constitution. Point 2. Retroactive civil liability usually only needs to meet a rational basis test. Retroactive civil liability usually only has to meet a rational basis test. Imagine that the government decides to adopt a law now to create civil liability on those who have dumped toxic wastes previously. Well, they were doing it. It might not have a basis for liability, but today Congress wants to create a basis for civil liability. So long as it meets a rational basis test, that's permissible. In fact, Congress did exactly that in the Superfund Act, creating retroactive civil liability on those who had dumped wastes already. A challenge was brought, and the court said, it's not a criminal punishment, so the ex post facto clause doesn't apply. It's civil liability, and that's allowed so long as it meets rational basis review, so long as it's rationally related to a legitimate government purpose. Point 3 with regard to retroactive legislation is the Contracts Clause. A specific provision of the Constitution that does limit retroactive government actions is the Contract Clause. The Contracts Clause is found in Article 1, Section 10 of the Constitution. It says, no state shall impair the obligations of contracts. With regard to this provision, no state shall impair the obligation of contracts, there are several things that the Supreme Court has held. A, the Contracts Clause applies only to state or local interference with already existing contracts. The Contracts Clause applies only to state or local interference with already existing contracts. I want to highlight a couple of things in that statement. Notice the Contracts Clause never applies to the federal government. Even if the federal government is interfering with existing contracts, you can't use the Contract Clause against it. It applies only to state and local governments. And notice also it applies only if the state or local governments are interfering with already existing contracts. The Contracts Clause doesn't limit the ability of the state or local government to regulate the terms of future contracts that have yet to be entered into. In this way, it is about retroactive legislation. Sub B, state and local governments may interfere with existing private contracts if intermediate scrutiny is met. State and local governments may interfere with existing private contracts if intermediate scrutiny is met. Now, the traditional definition of intermediate scrutiny is that the government must show that its action is substantially related to an important government purpose. Here, the test is a bit different than traditional intermediate scrutiny. Now, initially, the party must show that there is a substantial burdening of rights under existing contracts. Assuming there's a substantial burdening of rights under existing contracts, then, in order for the law to be upheld, it must be found to be reasonably and narrowly tailored to serve a legitimate and important government purpose. In order for a law that regulates private contracts to be upheld, it must be shown to be reasonably and narrowly tailored to serve a legitimate and important government purpose. This is a strange test because it's got language of rational basis review and language of intermediate scrutiny. I think it's safe to call it intermediate scrutiny, but you also should know how it's different from the traditional form of intermediate scrutiny. In sub C, with regard to the Contracts Clause, state and local governments may interfere with existing government contracts only if they meet strict scrutiny. State and local governments may interfere with existing government contracts only if they meet strict scrutiny. The Supreme Court has said that it's very suspicious if a state or local government tries to get out of its own contractual obligations without paying contract damages. And so the Supreme Court has said that a state or local government can abrogate its own contracts only if it meets strict scrutiny. Thus far, under subpoint B, with regard to retroactive legislation, I've discussed the ex post facto clause, I've discussed retroactive civil litigation legislation in rational basis review, I've discussed the contract clause. I want, for the sake of completeness, to talk about a fourth constitutional provision, so it would be point 4 under subunit B, and that's the prohibition of bills of attainder. I so often get asked by my students, what's the difference between an ex post facto law and a bill of attainder? And I thought it worth covering here. A bill of attainder is a law that directs the punishment of a person or persons without a trial. A bill of attainder is a law that directs the punishment of a persons or persons without a trial. If California would adopt a law saying Erwin Chemerinsky shall be put to death, that's an obviously unconstitutional bill of attainder. So I'm not covering bill of attainders because they're a form of retroactive punishment. I'm covering bill of attainders because they often get mentioned at the same time as the prohibition of ex post facto laws. In fact, they're found in the same constitutional provisions. So that's my second major topic in this module, the limits on retroactive legislation. My third major topic, sub C for this module, is procedural due process. The Constitution and the 5th and 14th Amendments, respectively, say that neither the federal nor the state governments can deprive any person of life, liberty, or property without due process of law. Procedural due process, as the phrase implies, refers to the procedures that government must follow when it's taking away a person's life, liberty, or property. Typically, procedural due process is about what kind of notice, what kind of hearing must the government provide when it's taking away somebody's life, liberty, or property. All procedural due process questions can be broken down into two issues. Point 1, has there been a deprivation of life, liberty, or property? Only if there has been a deprivation is the government required to provide due process. Under point 1, sub A, definitions. I want to define a couple of crucial concepts for you here. Under definitions, the first is that a deprivation of liberty occurs if there's the loss of a significant freedom provided by the Constitution or a statute. There's a deprivation of liberty if there's the loss of a significant freedom provided by the Constitution or a statute. In other words, it's the written law, the Constitution and statutes that create liberty interests. Usually, a liberty interest is a right that's created by the Constitution. The rights under the Constitution are obviously a crucial aspect of our liberty. But let me highlight for you some less obvious examples with regard to this definition of deprivations of liberty. One example, except in an emergency, before an adult can be institutionalized, there must be notice and a hearing. Except in an emergency, before an adult can be institutionalized, there must be notice and a hearing. Obviously, if a person is committed to an institution, he or she has less freedom. Therefore, in general, before there can be commitment, there must be notice and a hearing. The only exception is if there's an emergency. Another example with regard to this definition of deprivations of liberty, when a parent institutionalizes a child, there only has to be a screening by a neutral fact finder. If it's a parent institutionalizing a child, there only has to be a screening by a neutral fact finder. The Supreme Court says that it assumes that parents act in the best interest of their children, even if the parent is institutionalizing the child. So all the child is entitled to is a screening procedure where a doctor or other neutral fact finder approves the commitment. Third example, harm to reputation by itself is not a loss of liberty. Harm to reputation by itself is not a loss of liberty. This was initially the holding in Paul versus Davis in 1976. Louisville, Kentucky had the practice of posting shoplifters' pictures in department stores. An individual claimed that his picture was wrongly posted, and he sued, said the government had deprived him of his liberty, his reputation, without due process. The Supreme Court ruled in favor of the government. The Supreme Court later reaffirmed, harm to reputation by itself is not a loss of liberty. Fourth and final example with regard to this definition of deprivations of liberty, prisoners rarely have liberty interests. Prisoners rarely have liberty interests. When prisoners sue, asserting a loss of liberty, seeking due process, they almost always lose. Little two, a deprivation of property occurs if a person has an entitlement and that entitlement is not fulfilled. A deprivation of property occurs if a person has an entitlement and that entitlement is not fulfilled. Prior to the late 1960s, the Supreme Court drew a distinction between rights and privileges for the purpose of due process analysis. The Supreme Court used to say that the government had to provide due process if it was a right that was taken away, but the government wouldn't have to provide due process if it was a privilege that was taken away. But in the late 1960s, the Supreme Court discarded the rights-privileges distinction for due process analysis. No longer is it used. The new magic word is entitlement. A person has a property interest if there's an entitlement. An entitlement exists if there's a reasonable expectation to continued receipt of a benefit. There's property if there's an entitlement. An entitlement exists if there's a reasonable expectation to continued receipt of a benefit. To illustrate, I want to compare two examples. First example, a person works for the government and the government says to the individual, the job is yours for the next year. But in the middle of the year, the government fires the person. Was the person entitled to due process? Yes. The government created a reasonable expectation that the job would be there for the year. When it was taken away in the middle of the year, property was deprived, due process required. Compare this with another example. It comes from a Supreme Court case you might remember, Roth versus Board of Regents. Roth worked for the University of Wisconsin system on a year-to-year contract. Each contract made it clear that he should have no expectation that the contract would be renewed. The contract expired. It was not renewed. Roth sued and said he should be given due process with regard to the non-renewal. Was the government there required to give him due process? No. Though the gripes of Roth were great, he had no reasonable expectation that the contract renewed. He had no property interest, so no due process was required. So that's A under point 1, the definitions. Sub B under point 1, government negligence is insufficient to state a claim under due process. Due process generally requires an intentional, or at least a reckless government action. Negligence is insufficient to state a claim under due process. Due process generally requires an intentional, or at least a reckless government action. This was initially the holding of a Supreme Court case in Daniels versus Williams almost 30 years ago. A prisoner slipped on a pillow that had been negligently left on a prison step. The prisoner argued that the prison's negligence had cost him his body safety, his liberty without due process. The Supreme Court ruled against the prisoner. The court held more generally that negligence by the government is not enough for a claim under due process. There generally has to be an intentional, or at least a reckless government act. However, in emergency situations, the government can be held liable only if the officer's conduct shocks the conscience. In emergency situations, the government can be held liable only if the officer's conduct shocks the conscience. This was the holding of Sacramento County versus Lewis, 1998. Sacramento County versus Lewis in 1998 involved a high-speed police chase that ended tragically in the death of a teenage boy. The boy's parents sued the local government, saying that the officer's recklessness had cost the boy his life without due process. But the Supreme Court ruled in favor of the government. The Supreme Court said, in an emergency situation, like a high-speed chase, the government will be held liable only if the officer's conduct, quote, shocks the conscience. The court said, this requires proving that the officers acted with the intent of causing the harm to the victim. And finally, sub C, generally, the government's failure to protect people from privately inflicted harms does not violate due process. Generally, the government's failure to protect people from privately inflicted harms does not violate due process. This was the holding of a very important Supreme Court case, DeShaney versus Winnebago County Department of Social Services in 1989. Joshua DeShaney was a 4-year-old boy who was severely beaten by his father and suffered irreversible brain damage. Joshua's guardian sued the Department of Social Services, saying its failure to respond to child abuse complaints over a 2-year period cost Joshua's liberty without due process. The Supreme Court ruled against Joshua. The Supreme Court said the government had no duty to protect Joshua from his father. More generally, the Supreme Court said the government has no duty to protect people from privately inflicted harms. Only if the government literally creates the danger, or only if a person is in government custody, does the government have any duty to provide protection. Only if the government literally creates the danger, or only if the person is in government custody, does the government have any duty to provide protection. So that's point 1. Has there been a deprivation of life, liberty, or property? Only if you conclude that there has been, need you go to point 2. What procedures are required? With regard to the question, what procedures are required, sub A is the test. In Matthews versus Eldridge in 1976, the Supreme Court articulated a 3-part balancing test for determining what procedures are required when a person has been deprived of life, liberty, or property. The court says it balances little one, the importance of the interest to the individual. Obviously, the more important the interest to the individual, the more in the way of procedural protections the court will require. The court says it balances little two, the ability of additional procedures to increase the accuracy of the fact-finding. The ability of additional procedures to increase the accuracy of the fact-finding. The more additional procedures will lead to better, more accurate decisions. The more additional procedures will reduce the risk of an erroneous deprivation of life, liberty, or property, the more the court require them. And the court balances little three, the government's interest. The government's interest is usually in efficiency. It's usually in saving money. As you would guess, with a three-part balancing test like this, courts have a great deal of discretion. It's difficult to predict what the result will be. Let me go through some of the most important examples where the Supreme Court has applied this test and has specified what procedures are required. I want to go through a number of examples under sub B. First example, before welfare benefits can be terminated, there must be notice into hearing. Before a person's welfare benefits can be terminated, there must be notice into hearing. Second example, when Social Security disability benefits are terminated, there need be only a post-termination hearing. When it's Social Security disability benefits that are terminated, there only has to be a post-termination hearing. So remember, if it's welfare benefits, notice and hearing has to come before they're cut off. But if it's Social Security disability benefits, there can be a cutoff of benefits followed by the hearing. Third example, when a student is disciplined by a public school, there's to be notice of the charges and an opportunity to respond. When a student is disciplined by a public school, there's to be notice of the charges and an opportunity to respond. There doesn't have to be a trial type hearing. So the student has to be given notice, has to be given chance to respond, like to a principal or other administrator, but there doesn't have to be a full trial type hearing. One qualification is to this: corporal punishment in schools does not require any due process. Corporal punishment in schools, like spanking, doesn't require any due process. Fourth example, when a state goes to permanently terminate parental custody, there must be notice into hearing provided first. When a state seeks to terminate parental custody, there must be notice into hearing provided first. If the state is seeking to permanently end a parent's relationship with a child, the state is going to have to provide due process. Before parental custody can be permanently cut off, there has to be notice, there has to be a hearing. Fifth example, punitive damages require instructions to the jury and judicial review. Punitive damages require instructions to the jury and judicial review. There have been a number of cases involving due process challenges to large punitive damage awards. The Supreme Court has said that procedural due process requires that there be instructions to the jury to guide its exercise discretion, and then judicial review to make sure that any award is reasonable. Additionally, the Supreme Court has said that, quote, grossly excessive punitive damages violate due process. Grossly excessive punitive damages violate due process. This was initially the holding in BMW versus Gore in 1996. Ira Gore was a doctor in Alabama. He bought a BMW. He discovered, to his horror, that a part of the car had been repainted because of acid rain damage, and that hadn't been disclosed to him. He sued, and the jury awarded him $4,000 in compensatory damages and $4 million in punitive damages. The Alabama Supreme Court reduced it to $2 million in punitive damages. But the United States Supreme Court said that even the award of $2 million violated due process because it was, quote, grossly excessive. Sixth example. An American citizen detained as an enemy combatant must be given due process. An American citizen detained as an enemy combatant must be given due process. Yasser Hamdi was apprehended on the battlefield in Afghanistan. He was brought to the United States, where he was held as an enemy combatant. He sued seeking due process. The Supreme Court said the government had the authority to hold him as an enemy combatant, but the court said he had to be given due process. At a minimum, he had to be given notice of the charges against him. He had to be given representation by a lawyer. He had to be given a meaningful factual hearing. Seventh and final example, except in exigent circumstances, prejudgment attachment or government seizure of assets must be preceded by notice into hearing. Except in exigent circumstances, government forfeiture or seizure of property must be preceded by notice into hearing. If a court attaches a person's property, or if property is seized under a forfeiture law, the ability of the person to sell, maybe even to use the property, is limited. So the Supreme Court has said generally that attachment or seizure under a forfeiture law has to be preceded by notice in a hearing. The only exception the court has recognized is for so-called exigent circumstances. If there's reason to believe that the person would get rid of the property, if there's notice before the hearing, then there could be attachment or seizure, then immediately followed by notice into hearing. One qualification is to this, and that is the government may seize property that's used in illegal activities, even if it has an innocent owner. The government may seize property that's used in illegal activities, even if it has an innocent owner. This is the holding of Bennis versus Michigan in 1996. A man in Michigan was driving his car, and he stopped and picked up a prostitute. He went to what he thought was a secluded spot. It wasn't. A police officer came upon them. The man was arrested for lewd and lascivious conduct. The woman was arrested for prostitution. Additionally, the state of Michigan seized the car that he was driving. Michigan seized his car under a state law that allowed for, quote, abating a public nuisance. I guess the idea is once a car gets a taste for such things, there's no stopping it. Well, it turns out that his car was jointly owned with his wife, Tina Bennis. You can only imagine the conversation as he explained to his wife where the family car had gone. She sued and said it violated her rights to take away the car because she had done nothing wrong. She was an owner of the car and an innocent owner at that. The Supreme Court ruled against her. The court said when property is used in illegal activity, the government may seize it, even if it has an innocent owner. So whenever you're dealing with procedural due process, there's always two questions. First, has there been a deprivation of life, liberty, or property? Only if you conclude that there has been do you go to the second question, what procedures are required? That completes my third topic in this module, focusing on procedural due process. My fourth and final topic, sub D, is the Takings Clause. The Takings Clause is found in the Fifth Amendment. It says that government may take private property for public use, but it must pay just compensation. With regard to the Takings Clause, the court does not use the traditional levels of scrutiny. Rather, there's a separate test just for the Takings Clause. Analysis always starts with point one. Is there a taking? There are two alternative ways of finding a taking, either sufficient. A is called a possessory taking. If the government confiscates or physically occupies property, it's a taking. It's called a possessory taking. If the government confiscates or physically occupies property, that's a taking, a possessory taking. An example from a recent Supreme Court case, Horn versus United States Department of Agriculture, June 2015. Under a 1937 federal statute, Congress requires that farmers turn over a portion of their crop when requested to do so by the Department of Agriculture. This was Congress trying to create price stability for agricultural products. If there's too much of a product on the market, that will depress prices. That will mean there won't be enough incentive to grow that crop in the future. By removing some of the crop from the market, it drives up prices and creates an incentive to keep growing the crop. Well, Horn involved application of this 1937 federal statute to the raisin crop. Every year, the Department of Agriculture tells raisin growers how much of their raisins they have to turn over to the federal government. The Supreme Court ruled 5-4 that this is a taking, and the government's going to pay just compensation. The court said, this is the government confiscating the raisins, taking the raisins to do things like put them in school lunches. The court said, this is a taking, and it requires just compensation. So if it's a per se or physical taking, possessory taking, then it's clear that the government is going to have to pay just compensation. In fact, it doesn't matter how small the amount of property involved is. If the government confiscates it or physically occupies it, that's a taking. You might remember here from law school the case Loretto versus teleprompter. New York City adopted an ordinance that required that apartment building owners make available space for cable television boxes. The amount of space involved was just 1 cubic foot. Nonetheless, the Supreme Court said that it was a taking, albeit one requiring only nominal compensation, because the government had confiscated that property, at least the small amount of property that was involved in that litigation. The other way of finding a taking is called a regulatory taking. So you can have a possessory taking, or the other way of finding a taking is a regulatory taking. Government regulation is a taking if it leaves no reasonable, economically viable use of the property. Government regulation is a taking if it leaves no viable, economically viable use of the property. In other words, government regulation is not a taking simply because it decreases the value of a person's property. Government regulation becomes a taking only it leaves no reasonable, economically viable use of the property. To illustrate, I want to compare two Supreme Court cases you might remember. One is Penn Central versus New York City. Company bought Grand Central Station in New York, hoping to place an additional structure on top of it. Subsequent to the purchase, the city adopted a historic preservation law that prevented the new construction. The owners sued and said, the government had decreased the value of their investment, the government should have to pay. The Supreme Court ruled in favor of the city. The Supreme Court acknowledged that the government had decreased the value of the investment, but the court said the owners still had economically viable use of the property that was there. Therefore, it was not a regulatory taking. Compare this to another case you might remember, Lucas versus South Carolina Coastal Council. David Lucas bought a piece of beachfront property in South Carolina for almost $1 million. Subsequent to purchase, the state adopted a coastal protection law that prevented any development of Lucas's property. Lucas sued and he won. The Supreme Court said since the state was preventing any economically viable use, that made it a regulatory taking. There are a few more specific rules that you need to know with regard to regulatory takings. One rule to note with regard to regulatory takings is that government conditions on the development of property must be justified by a benefit that's roughly proportionate to the burden imposed. Otherwise, it's a taking. Government conditions on the development of property must be justified by a benefit that's roughly proportionate to the burden imposed. Otherwise, it's a taking. Frequently, especially local governments, try to put conditions on the development of property. Property owners often try to argue that those conditions are a regulatory taking. The Supreme Court has said, so long as the benefit to the government is roughly proportional to the burden on the landowner, it's not a regulatory taking. But if the burden on the property owner is excessive relative to the benefits of the government, then that is a regulatory taking. The second principle to note with regard to regulatory takings here is that a property owner may bring a takings challenge even as to regulations that were already in place when the property was acquired. A property owner may bring a takings challenge even as to regulations that were already in place when the property was acquired. Imagine there's a piece of property that can't be developed because of a zoning ordinance or an environmental law. Imagine a person buys the property knowing of this restriction on development. That person can bring a takings challenge even though the regulations were already in place when the property was acquired. And the final note here with regard to regulatory takings is that temporarily denying an owner development of property is not a taking so long as the government's action is reasonable. Temporarily denying an owner development of property is not a taking so long as the government's action is reasonable. Lake Tahoe imposed a 3-year moratorium on development for purpose of doing an environmental study. The property owners who could not develop their property during this time said the government should have to compensate them for the loss. The Supreme Court ruled in favor of the government. The Supreme Court said, temporarily denying the owners the ability to develop this property is not a taking because the government's action was reasonable. The delay in construction for purpose of an environmental study was something desirable for government to do. So if either there is a possessory taking or a regulatory taking, then you go to point 2, is it for public use? The government can take private property, but only for public use. If it's not for public use, the government is going to have to give the property back. But the Supreme Court has defined public use so that virtually every taking will meet this requirement. The court has said that a taking is for public use so long as the government acts out of a reasonable belief that the taking will benefit the public. A taking is for public use so long as the government acts out of a reasonable belief that the taking will benefit the public. This was the holding of a Supreme Court case that was quite controversial that came down about a decade ago, the Kelo case. It involved a town in Connecticut that was economically depressed. The city decided to use its eminent domain power and take title away from homeowners, pay them just compensation, and then sell to developers. Some homeowners didn't want to sell their property. And so they challenged us and said, for the government to take title from some private owners to sell to other private owners isn't for public use. The Supreme Court ruled in favor of the city. The Supreme Court said the taking was for public use because the government was acting out of a reasonable belief that taking the property and selling to developers would lead to more jobs, more economic growth. And the Supreme Court reiterated what held previously. A taking is for public use so long as the government acts out of a reasonable belief that the taking will benefit the public. And finally, point 3, is just compensation paid? Is just compensation paid? The government can take private property for public use, but it has to pay just compensation. The measure of just compensation is in terms of the loss to the owner in reasonable market value terms. The gain to the taker is irrelevant. Just compensation is measured in terms of the loss to the owner in reasonable market value terms. The gain to the taker, the government, is irrelevant. Imagine a person owns a piece of property with a reasonable market value of $100,000. Imagine the government's going to take the property, get $10 million of benefits in the property. What does the government have to pay in just compensation? $100,000. The reasonable market value in the owner's hands. The gain to the government, the taker, is irrelevant. So whenever you've got a takings question, whenever you're dealing with a takings issue, there's always a sequence of analysis. First, is there a taking? Is there either a possessory or a regulatory taking? If so, but only if so, you go to question 2 and ask, is it for public use? The Supreme Court has so broadly defined public use as the government acting for reasonable belief the taking will benefit the public that virtually every taking meets this requirement. And then you get to question 3, is just compensation paid? Remember, just compensation is measured in terms of the loss to the owner. The gain to the government, the taker, is irrelevant. So this completes my discussion in this module of individual liberties. I've focused with regard to this module on the requirement for state action, the limits on retroactive legislation, on procedural due process, and on the takings clause.